Well, William Wagner, it's Monday. It's almost 25 past 1. Covering the case in Los Angeles, the case of Conrad Murray for the involuntary manslaughter of Michael Jackson, when everything he did to get him dead was a voluntary act. The jury found him today guilty, as I predicted. The jury had actually pretty much made up their mind Friday. Now the real question is, will Conrad Murray get the maximum 4 years, or will he get home detention? Will he actually serve 4 years, or has the law been changed in California by SB 312 so that he cannot be put in the state prison and can only serve time in the overflowing LA jail, which would mean home detention and an ankle bracelet? The sentencing will be probably in 5 days. But if the fans had their way, he'd be hung by the courthouse yardarms where the American flag flies today. I'm William Wagner, bringing you the scoop of the trial in Los Angeles. And I can tell you from my fans on the street in Los Angeles, there's about 50 to 75 and more gathering. This is not the big deal. The big deal will be whether he serves even 30 days in the county jail or walks out with an ankle bracelet. I'm William Wagner, bringing you the scoop. Here it is, the verdict.
This is the case of People versus Conrad Robert Murray, case SA 073164. Dr. Murray is present in court with counsel, Mr. Chernoff, Mr. Flanagan, Mr. Gorgian. The people by counsel, Mr. Walgren and Ms. Brazil. All alternates are present. All regular members of the jury are present. To everybody, good afternoon. Ladies and gentlemen of the jury, I am advised that the jury has reached a verdict. Who is the foreperson of the jury? Juror number 3? Thank you, sir.
Yes, sir.
Do you have all the verdict forms with you?
Yes.
Could you provide the verdict forms to Deputy Jones, who will then present them to me? Court has reviewed the verdict form, and ladies and gentlemen, there was a typo in terms of the date of the alleged incident. It was written June 9th, 2009, and juror number 3, you've corrected that to June 25th. You put a 2-5 and you put some squigglies after that?
Yes, sir.
All right, thank you. I reviewed the verdict form, which now I will pass to Mrs. Benson, the court clerk. Mrs. Benson will publish the verdict.
Superior Court of California, Los Angeles County. The people of the state of California plaintiff versus Conrad Robert Murray, defendant. Case number SA 073164. Title of court and cause. We, the jury in the above entitled action, find the defendant, Conrad Robert Murray, guilty of the crime of involuntary manslaughter in violation of Penal Code Section 192, subsection B. Alleged victim, Michael Joseph Jackson. Alleged date of June 25th, 2009. As charged in count 1 of the information. This 7th day of November 2011, 4-person juror ID number 145, seat number 3. Is this your verdict? Is this your individual and personal verdict? So say you one, so say you all.
Yes. All jurors indicating the affirmative. Ladies and gentlemen, I'm going to ask you whether this is your individual and personal verdict. If it is your individual and personal verdict, say yes. If it is not your individual and personal verdict, say no. Is this your individual and personal verdict, Juror 1?
Yes, sir.
Juror 2?
Yes, sir.
Juror 3?
Yes.
Juror 4?
Yes, sir.
Juror 5?
Yes.
Juror 6?
Yes.
Juror 7?
Yes.
Juror 8?
Yes.
Juror 9?
Yes.
Juror 10?
Yes, sir.
Juror number 11?
Yes.
Juror 12?
Yes, sir.
All jurors having indicated in the affirmative, the court clerk is directed to record the verdict. Do counsel waive further reading of the verdict as recorded? Mr. Waldman?
Yes, Your Honor.
Mr. Chernoff?
Yes.
Thank you. Ladies and gentlemen of the jury, I now will read to you final instructions upon discharge of jurors. You now have completed your jury service on this case. On behalf of all of the employees of the Los Angeles Superior Court and the parties in this case and others involved in this case, Please accept my thanks for your time and effort. Throughout this trial, I have admonished each of you not to discuss anything about this case with anyone other than a fellow juror during deliberations in the jury room. That order is lifted and vacated, and protection. The lawyers in this case, the defendant or their representatives, now may talk to you about the case, including your deliberations or verdict. Those discussions must occur at a reasonable time and place, and only with your consent. Please immediately report to the court any unreasonable contact made without your consent by the lawyers in this case, the defendant, or their representatives. A lawyer, defendant, or representative who violates these rules violates a court order and may be fined. I hereby order that the court's record of personal juror identifying information, including names, addresses, and telephone numbers, be sealed until further order of this court. Would be a hardship, an inconvenience, and burden on you, because you have your own lives outside of this courtroom. You have responsibilities to your jobs, to your profession, and to your families. You have undertaken the responsibility of jury duty in a remarkable fashion, as do jurors every day throughout this great country. You have made sacrifices, and you certainly have had to endure burdens in your civic duty. I'm going to ask that you accommodate us a little bit more by going back into the jury room and just relaxing for a few minutes. I and some of our court staff members want to go in and thank you individually for your sacrifices. So once again, ladies and gentlemen, on behalf of all those involved in the case, thank you for being jurors in this case. And again, I want to wish you the very best. We stand for jurors in this courtroom, and it's not standing for them in terms of tolerating them. We actually stand up for jurors, and people want to know why we do that. Well, we do it because we respect you and because we appreciate you. And that's why at every session in this case, we have stood for jurors, and why now again, those of us will stand for you as well. My best wishes. You are discharged and excused. Jurors have left the courtroom. Thank you. All right, with regard to further proceedings in this case, Mr. Chernoff?
Judge, you're asking about sentencing?
Any motion and probation and sentencing. Dr. Murray has a statutory right to speedy sentencing within 20 court days after today's date, which means on or before December 8th, 2011.
At this time, we would ask that he be remanded with no bail pending sentencing on November 29th, 2011.
Do not apply in this case. For 18 months, Dr. Murray has been on bail, has not violated any of the rules of the court, has not been a flight risk, has not been a danger to the community. He continues that way. He has family obligations that he has to take care of. The fact that this was a possibility doesn't mean that those obligations don't need to be taken care of. There's no reason to remand him under the circumstances, and we ask that you release him OR until sentencing date of 29th of September. November.
Is the matter submitted, Mr. Chernoff?
It is.
Mr. Waldron?
Yes, Your Honor.
Thank you. The court takes into account the factors in Penal Code sections 1166 and 1272. Throughout this trial, Dr. Murray was presumed innocent, and certainly there is a constitutional guarantee of bail to pre-conviction status. Dr. Murray has been convicted of a felony by the jury. The jurors found beyond a reasonable doubt, unanimously, that Dr. Murray is in fact guilty of the crime of involuntary manslaughter. There is no statutory right to bail based upon this felony conviction. The court does evaluate the defense request for continued release on OR and bail pursuant to the provisions of the Penal Code sections to which I referred. The defendant shall be committed to the proper custody of the county to await judgment of the court upon the general verdict, unless, upon considering certain factors, the evidence supports a decision to allow Dr. Murray to remain out of custody on bond. The first factor is the protection of the public. Quite frankly, I feel that that is a significant and demonstrable factor in this case, and public protection, as far as I'm concerned, dictates that the defendant be remanded without bail in view of the fact that Dr. Murray has been convicted of a crime involving homicide. This is not a crime involving mistake of judgment. This is not a crime involving administration of drugs per se. This is a crime where the end result was the death of a human being. That factor demonstrates rather dramatically that the public should be protected. Secondly, the seriousness of the offense charged and proven. The offense charged and proven in this case is a homicide, and the homicide is predicated upon criminal negligence in this case. As far as I'm concerned, that factor is a significant factor in terms of remand. Third, the previous criminal record of the defendant. As far as I know, that criminal record is non-existent, and that is a factor which would indicate to the court that Dr. Murray should remain on his posted bond. The fourth factor is the probability of the defendant failing to appear for the judgment of the court upon the verdict. Dr. Murray has made all of his court appearances. He has been represented by counsel. He has made appearances in the past. Quite frankly, I don't know if Dr. Murray would in fact make those appearances in the future, since he now is a convicted felon, and Dr. Murray has significant ties outside of the state of California. So I genuinely am not sure about this factor. The fifth factor is, once again, an overriding consideration, and that is public safety. Dr. Murray's reckless conduct in this case poses a demonstrable risk to the safety of the public. If Dr. Murray remains out of custody on bond, and even though Dr. Murray is a medical doctor, and even though he has been practicing, public safety demands that he be remanded. Based upon my evaluation of all of these factors, I conclude that remand is appropriate. Dr. Murray is remanded to the custody of the Los Angeles Sheriff with no bail, and in the interim, he is to be kept in the care and custody of the Sheriff and ordered to appear for further proceedings and formal probation and sentencing on 29 November 2011 at 8:30 a.m. in this department. I expect that the people will have specific restitution, we can wait a few moments, specific restitution related issues in this case, pursuant to the provisions of Penal Code Section 1202.4, and be prepared to address any matters of restitution. Certainly, counsel are aware of the Realignment Act and the provisions of Penal Code Section 1170, subdivision. I'm going to excuse myself, and we can.
Here's the outside scene at the courthouse. The fans will not get a chance to throw sticks and stones at Murray. He's going into custody at least till the 29th. And this is the crowd. About 50 people wanted Murray locked up. There were 2 or 3 standing around calling for his acquittal and saying he was still innocent. We don't see those people around anymore.
That, by the way, that's here's Catherine. What did she say, Raquel? She said justice is served. Catherine just looked at the microphone and Fox 11.